Good morning, everyone. Thanks for joining us for the employment webinar today. We've got about 70 odd people that have dialed in so far. I'm aware that we've got significantly more people that have signed up, so we'll just wait a minute or so, if that's okay, before we start off. But thanks for dialing in, and hope you are all having a lovely morning. Okay, look, it's a couple of minutes past 10, so I think we'll start off. This session is recorded, so for any colleagues or people that dial in a few minutes, we will be able to recirculate the recording, so please don't worry about that. So I'm Robert Forsyth, a partner in the employment team here at Mitchell Moores, based in our London office in Liverpool Street. And I'm excited to be joined by two fantastic colleagues. First up, we have Lindsay Blythe, who's a partner in our employment and immigration team. Lindsay, it's great to have you here.
Thanks, Robert. Morning, everyone. I am really looking forward to today's discussion, so it's great to be here with you all. Thanks.
Thanks, Lindsay. And we're also joined by James Millett, an associate in our team here in London. James, welcome.
Good morning, everyone. Great to be part of the session today.
The next 2 years will bring unprecedented changes in employment law for employers and employees. In this webinar, we will be touching on 4 key topics. The Employment Rights Bill, which currently stands at just over 50,000 words for those looking for a quiz trivia question over the next couple of weeks. Apprenticeships, flexible working, and discrimination compensation. We have had a number of questions that have been sent in ahead of the webinar, so if we have time at the end, then we will answer those. But if you do have questions, please do, there is a chat facility, so please do just pop them into the chat facility, and we will then try to cover those off either at the end of this webinar, or if there isn't time, then we'll come back to you separately on those. So please do use the chat facility. In terms of our details and contact details, those will all be there at the end of the webinar. So that will all be self-explanatory. We're going to start off by looking at the Employment Rights Bill, which will fundamentally change the employment law landscape and give employees far greater rights at work. The government's firm belief is that giving employees greater rights is good news for business, as it will lead to more productive and committed employees. James, the one reform that everyone seems to be talking about is the change to unfair dismissal law to make it a day one right. Currently, as I'm sure most of you will be aware, you can't bring an ordinary unfair dismissal claim in the first 2 years of service. But James, can you explain what is proposed and how that will impact businesses, please?
Thanks, Robert. And yes, of course, this is the one that everyone wants to hear about. So as you say, at the moment, employees must have at least 2 years continuous service in order to bring an ordinary unfair dismissal claim against their employer. Under the Employment Rights Bill, unfair dismissal will become a day one right for employees. This will, however, be subject to a new modified light touch dismissal procedure applicable in most cases during an initial period of employment. Now, to begin to understand the impact of this change, the government's own estimation suggests this would bring approximately an additional 9 million employees within scope and give these individuals unfair dismissal rights?
Thanks, James. 9 million, just to put that into context, that is over 25% of the UK workforce. So the UK workforce is currently about 34 million. So that is a sizable increase. And again, for anyone interested in stats, there are an additional 9 million people who are of working age, but who are out of work. So there's roughly 43 million people of working age, but only 34 million people in work. So it's a big change, to put it into context. James, do we have details about what this light touch dismissal procedure will actually look like, and how long the, in inverted commas, initial period of employment will be?
So much of the detail will be contained in regulations and is as yet unknown. The government has indicated a preference for the initial period of employment to be 9 months, but this will be subject to consultation. Equally, we don't yet know what the light touch procedure will look like, but as a starting point, the government has suggested that it should consist of holding a meeting with the employee to explain the concerns about their performance, at which the employee could choose to be accompanied by a trade union representative or a colleague. There's not yet mention of any requirement to write a letter. However, most employers are likely to want to write to an employee to ensure that there is a paper trail confirming the reason for dismissal in the event of any future disputes.
Thanks, James. I mean, that is a significant change to the current position, and will no doubt lead to a significant increase in the number of tribunal claims that we see. And you can see there being a significant battleground in terms of whatever this sort of light touch period is, so the 9 months. And so I think effectively you'll need to treat it as if you'd have an employee who'd been there for sort of 3 or 4 years currently, because the same factors will all come into play. Do we know when those reforms will take effect yet, James?
So the government has confirmed that the unfair dismissal reforms will not take effect until at least autumn 2026, to allow consultation to take place and to give employers time to prepare for changes. So until then, the current qualifying period of 2 year service, that will continue to apply.
Okay, thank you. And ahead of those changes that will come in autumn 2026, is there anything that employers can be doing or thinking about in terms of preparation?
So whilst immediate action is not needed until we have further details of the reforms, employers should consider formulating strategies and procedures for more robust pre-employment screenings and checks, with the aim of ensuring that new hires are right for the job before they're taken on. Once an individual starts work, they'll need to be proactively managed and their performance monitored during the initial period of employment, which should involve regular reviews with their line manager. Employers should also ensure they're appropriately documenting any decisions relating to a dismissal, and managers should receive training on the new laws and the more proactive approach that will be expected of them.
Thanks, James. I think as a general comment, if there's a takeaway from this session, then training is going to be vitally important, not just for HR teams, but for managers within your business, to make sure that everyone's up to speed with all the different changes that are coming in. You know, there are a large number of changes. We're not covering everything in this session, but I mean, you know, we're already seeing employers being less keen to recruit, and thinking about where they recruit in terms of geography. So for those companies that have businesses or divisions abroad, then they are looking at increasing numbers there as opposed to the UK. So we've already had that in terms of sort of direct feedback from clients. So lots to consider, I think, when you're having those discussions with your boards about what the next sort of 2 to 3 years looks like from an employee UK perspective. In terms of other reforms, there are some big changes on the horizon for one of our favourites, which is fire and rehire. James, could you update us on that, please?
Yes, of course, and you are right. Fire and rehire, it's going to become even more difficult under the Employment Rights Bill. A dismissal will be automatically unfair if an employee refuses to agree to a change to their terms and conditions, or because an employer wants to replace that employee with another person on varied terms to carry out that role. So this covers both fire and rehire and fire and replace. There is a very limited exception to fire and rehire, which is when a company is facing a financial crisis and could not reasonably have avoided the need to make the variation, but this will rarely apply.
Thanks, James. So does that mean that employers who are looking to make contractual changes to employee terms and conditions that could end up in a fire and rehire situation if those changes are not agreed to by employees at an early stage, should they make those changes now rather than waiting for 12 or 18 months?
It's interesting. It's certainly something for employers to consider, though they will, of course, need to ensure that they're complying with the new statutory code of practice on dismissal and re-engagement, which warns that fire and rehire should only be used as a last resort after employers engage a thorough consultation process.
Yeah, thanks, James. I mean, we did, for those of you that dialed in last year, we did cover the changes that were made to fire and rehire last summer, autumn by the previous government. And these new changes make it harder yet. And I think the comment that I made last year was that they're likely those changes are likely to lead to more redundancies being made because changing terms and conditions is becoming so difficult and risky from a cost perspective if you get this wrong and you're not in line with the codes of practices, which are extensive. Then I think that's an unfortunate, probably unintended consequence. But we'll see what happens on that front. But definitely a lot to consider. We know that since October 2024, employers have been required to take reasonable steps to prevent sexual harassment of their employees during the course of their employment. And how will the Employment Rights Bill change this aspect, James?
So the bill will extend this duty so that employers are required to take all reasonable steps to prevent sexual harassment of their employees. So this is much more onerous. In practice, this will involve employers conducting detailed risk assessments to identify risks and put measures in place to address them, as well as ensuring policies are updated and targeted training is delivered on identifying and reporting sexual harassment. It will be important also to obtain staff feedback. This can be conducted in a number of ways, whether it be by anonymous engagement surveys or one-to-ones, and this feedback will be particularly helpful for HR teams who should be monitoring and evaluating actions to ensure that the processes in place are in fact effective.
I've no doubt that many of you will have already brought in changes to your policies and updates to your workforces, but this is one of those areas where you do need to make sure that you've got the appropriate training, you've updated your policies, that you're very, very clear, because if you receive grievances, complaints, claims, and you don't have those to point to, then you're really in a very, very difficult position in terms of defending those points and being able to forget the tribunal, but just being able to sort of reassure your employees that you're on top of the current obligations and law. In terms of changes that the Employment Rights Bill brought in, there is a really, really big change on the prevention of sexual harassment front, James, isn't there? And that relates to liability for third-party harassment. Could you cover that, please?
Yeah, that's right, Robert. So the bill will make employers liable if their employees are harassed by third parties. So that can include clients, customers.
Which is a big change to think that you are potentially responsible for the actions of anyone. So not your employees or even shareholders. It's third parties. So that is a big change and extension of liability for employers. What steps can businesses take to try and mitigate against that risk?
There are a number of steps that can be taken. Reviewing policies to include third-party harassment and reporting mechanisms, that will be important, as well as delivering targeted training. Risk assessments will continue to be crucial, and employers should work to mitigate any risks identified specific to third-party harassment. For example, this will include signposting the employer's approach to sexual harassment in contracts, in terms of business, and also having signage on site where it be applicable to do so.
Okay, thanks, James. So lots of work to do, but hopefully you'll be able to build on the work that you have already undertaken in terms of risk assessments, policy updates, and training. Now, we've also heard that there are plans to introduce mandatory ethnicity and disability pay gap reporting obligations for large employers. Can you tell us more about what's been released on that front, James?
Yes, of course. So the government plans to introduce the Equality, Race and Disability Bill, which would introduce mandatory disability and ethnicity pay gap reporting for employers with 250 or more employees, as well as extending equal pay rights to prevent workers from suffering discrimination on the basis of race or disability. It's currently consulting on how to introduce the pay gap reporting, with the consultation closing on the 10th of June this year, so in only a few weeks.
Thanks, James. And again, some of you who have divisions or entities abroad may already have to provide similar reports, particularly if you've got operations in California. But what's that likely to mean in practice for employers here, James?
So in truth, we'll know more once the consultation has finished and the government responds, but the government proposes to use a similar framework, a similar reporting framework to that used for gender pay gap reporting to reduce the administrative burden on employers. So this would include reporting on the same 6 measures currently in place for gender pay gap reporting, as well as reporting on the overall breakdown of staff by disability and ethnicity, and identifying the percentage of employees choosing not to disclose this information.
Thanks, James. I mean, I think sort of looking ahead on that front, we all see in the news from time to time large equal pay claims, and I fully expect that there will be similar developments arising from reports that are produced on both disability and ethnicity. So I think it's something to sort of certainly bear in mind when you are evaluating roles and pay and benefits. Now moving on, James, before Labour came into power, one of the points that they were very clear on was that they planned to ban 0-hour contracts. However, that is not actually what has been proposed under the Employment Rights Bill, is it?
No, it's not. So the bill falls short of banning 0-hour contracts, but it does introduce a lot of changes to 0 hours and low-hour contracts. So under the bill, employers will need to provide 0-hour employees with reasonable notice of shifts and provide compensation for short notice shift cancellation and changes. Employers will also be bound to offer qualifying workers a guaranteed hours contract to reflect the hours they have worked during a reference period. The qualifying workers will be those on 0-hour contracts or low-hour contracts. We don't yet know what this low hours threshold will be, and we are also yet to get this confirmation of the exact duration of the reference period, although it is anticipated to be 12 weeks.
Thanks, James. So again, a fair amount of detail that we're waiting on, but again, that is a big area of change that we will all need to be on top of. For those businesses that use 0 hours workers, it's certainly going to be sensible to conduct an audit to understand how your labour needs fluctuate and how that could impact your business, as well as ensuring that you've got a structured scheduling process to manage shift allocation and any changes to those shifts. Now, with employees being given additional rights, in terms of taking steps to enforce those rights, that's likely to lead to more claims, as has been commented on throughout the media over the last sort of 6 months or so. The tribunal system's already fairly stretched, isn't it, James? So what do we foresee on that front?
Sorry, Naomi, if we could just get back to the previous slide. So as you say, the tribunal is already pushed to its limits. I'm seeing this. I'm currently advising on a tribunal matter, and the final hearing has been listed for June 2027. So we're already seeing a significant backlog in the employment tribunal. It is possible that it will become commonplace for the lifespan of employment tribunal claims to be 2 years plus, as we expect that there are going to be more claims with employees gaining more rights. And on that point, it's worth noting that the time limit for bringing employment tribunal claims will be extended by the bill. So for most claims, employees currently have 3 months to bring a claim that's subject to ACAS early conciliation rules, but the bill will extend this to 6 months, allowing employees more time.
Thanks, James. And on that front, I'm afraid the listing of hearings in 2027 is not an exception. Tribunals have been clear that for hearings that will be 4 days or more, 2027 is where they are looking, and 2028 for longer hearings. So we've got a huge backlog already in terms of claim management. So that is likely to only deteriorate. Lindsay, if we move away from the fun of the Employment Rights Bill, there have also been a number of changes to apprenticeships, which you kindly said that you would talk us through, please.
Yes. A nice change of pace, Robert. It's actually like to be some much needed good news for employers.
Right.
Much needed, right? Yeah. In February 2025, so this year, the government announced plans to reform the apprenticeship system in England, aiming to increase the number of apprentices by up to 10,000 per year. And the changes include giving employers more control over English and maths requirements by allowing them to decide whether adult learners need to complete a level 2 English and maths qualification to pass their apprenticeship, and shortening the minimum duration of an apprenticeship from 12 months to 8 months.
Great, thanks, Lindsay. That's as you say, that's going to be welcome news, isn't it, for employers in high demand sectors like health or social care. Do we know when those changes are going to come in?
Well, actually, the changes regarding the English and maths requirements have actually already come into effect. And then the change regarding the minimum length of the apprenticeship will come into effect in August this year.
Okay, thank you. So increased flexibility is obviously a positive, but the law on apprenticeships, and apologies because we are going to get a little bit technical now, is complex, isn't it? Yeah, well, I'm not sure. I have to say, I'm not sure where I'd come out in terms of sort of level 2 maths, but that's not for today. But
that's why you're a lawyer and not an accountant, Robert.
Correct. Apprenticeships. Could you talk us through some of the fairly prescriptive elements of apprenticeship law for those who can't sleep on a regular basis? You'll be able to replay this ad nauseam.
Yeah, it's a really kind of poor equivalent to the BBC bedtime stories. Well, listen, it's really prescriptive, but is really complex. And of course, to add kind of insult to injury, the law differs whether you're in England, Scotland, or Wales. And I guess put simply, unless you're dealing with it on a regular basis, it's really easy to miss the nuances. So if we focus on England, the oldest type of apprenticeship is a common law apprenticeship. Now, it's rarely used these days, but it still does exist for some apprenticeships. The distinguishing feature with the common law apprenticeship is that they offer enhanced protection from dismissal, and it's actually very hard and pretty risky to dismiss apprentice that's engaged under that type of apprenticeship. So early termination of a common law apprenticeship could entitle the apprentice to damages for loss of earnings and training for the remainder of the contract term, and for loss of future career prospects. By far the most common apprentice arrangement that we'll get in England, however, is the approved English apprenticeships. Now, perhaps if I kind of, Robert, if you're happy with me to do so, maybe if I can continue to bore people about this and talk about the details that those apprenticeships need to contain.
You started it, Lindsay, so I'm afraid you're going to need to finish it. I think the good news for everyone else, good news for everyone else is we're not going to cover off the Scottish or Welsh equivalents, but for those of you that have interests in those areas, then we're here all week. So please just come back to us afterwards. But yes, no, please do.
Fab. I did think you would do a pop quiz at the end and really test me on those, Robert, so I have been brushing up. So yes, please do come to us with any questions. Well, listen, it's crucial that employers comply with the statutory requirements for approved English apprenticeship agreements to avoid inadvertently actually creating the common law apprenticeship, which is obviously the thing we want to avoid. So approved English apprenticeship agreements should contain the basic terms of employment required to be given to employees under your Section 1 of the Employment Rights Act, just like any normal employee. But in addition, they also need to contain the start and end dates and therefore the duration of the apprenticeship. They need to confirm that the apprenticeship is a qualifying apprenticeship. It needs to clearly set out the length and the practical period of the apprenticeship. It also needs to confirm the specific trade, skill, or occupation the apprentice is being trained for, including the level of that apprenticeship. And then details of the training provider also need to be set out in that contract as well, in case the employer isn't actually providing the training themselves. The only other thing that we need to be talking about there is also whether or not there's any time spent on off-the-job training. So that's training outside of the apprentice's normal working hours. So that needs to be clearly outlined. And you also need to give a detailed outline of the training programme, including the modules, skills, and the knowledge the apprentice will require. And of course, as you would expect, clearly state that the agreement is governed by the laws of England and Wales. So yeah, quite a lot in there, Robert, and really key that you kind of hone in on those details, because otherwise you could come a cropper and get yourself bound by the common law apprenticeship rules, which we, as I say, we want to avoid.
Absolutely. Again, without wanting to sort of to worry people too much, but the other thing that you can end up with is you don't have an apprenticeship agreement at all, and you're then paying people at rates that are wildly out of kilter with what they're actually entitled to. So you mentioned it's really difficult to terminate a common law apprenticeship. Is that the same for an approved English apprenticeship?
No, thankfully, no. Normal rules for breach of contract and unfair dismissal apply to approved English apprenticeships. So these apprentices can be performance managed and dismissed just in the same way as any other employee, Robert.
Right, thanks, Lindsay. Although subject, of course, to James's good news on the day one rights, of course, from next autumn. So is there anything that employers can do to ensure that they are compliant with the laws and regulations that govern apprenticeships, Lindsay?
Oh, yeah, most definitely. Biggest compliance risk an employer could face here is probably the failure to comply with the apprenticeship funding rules. And failure to comply with these rules can actually result in either a partial or worse, a full clawback of the apprenticeship funding. So to avoid that, employers need to ensure that apprentices receive at least 6 hours per week of structured training, which is separate and therefore in addition to the tasks that they do on a day-to-day basis. They also need to ensure that they accurately maintain training records. I think most businesses are pretty hot on that, but often I see people fall down when you're kind of looking at apprentices which are in kind of more manual kind of roles, for example, in terms of mechanical things, tend to find that the training records are a little poor. That can come back and bite you, unfortunately. So making sure those are hot and accurate are very key. And of course, the other thing we need to make sure here is that employers are actually paying the apprentices the correct wage, and they need to be mindful. Obviously, you've got that kind of age kind of difference there that will happen during most apprenticeships. So when apprentices hit the age of 19, you have to remember that obviously you're required to pay them full national minimum wage for their age group.
Yeah, absolutely. Thanks, Lindsay. And training records will be imperative in terms of making sure that those are accurate as well. But that's really helpful. Thank you for that recap on apprenticeships. And we are now going to turn to some more good news that James will bring us. It's been just over a year, I think, since a number of changes were made to the flexible working laws in this country. Those changes were that employees were able to request to work flexibly from day one, so the first day of their employment, and they were also allowed to make 2 requests a year. Those changes were introduced at a time when employers were becoming more keen to encourage workers and employees back into the office and to return to more traditional working habits. James is a big Manchester United fan, and you probably saw in the news last year that they were all summoned back to the office 5 days a week. But aside from your beloved Manchester United, James, how have we seen those changes play out in practice?
Absolutely not my beloved Manchester United. I won't reveal who I support. But the changes to flexible working mean that more employees are eligible to make requests. And as you say, Robert, employees are also able to make 2 requests in a 12-month period. Asking people to return to the office is not always a popular decision. However, there are increased expectations of employees spending more time in the office. That is the reality. Now, with businesses trying to encourage people to work more frequently in the office, coupled with the bolstering of flexible working rights, this has meant that the number of flexible working requests has increased over the last year.
Thanks, James. And I mean, yes, that's absolutely right. We are seeing more flexible working requests come in. So the other point, just that as a sort of, well, it's not really a trivial point, is, but I'm sure everyone's seen in the news recently that there have been a number of people who've been working 2, or I think probably my favourite example was the person that had 3 public sector jobs at the same time, and I think had managed to perform those 3 jobs for over a year before they were caught. So I think that's what's driving some of the sort of some of the concerns in terms of sort of not hearing from people. I mean, those are outlier cases, obviously, but yeah, there is a trend, I think, to for all sorts of reasons, to sort of try and rebuild that team environment with more time in the office and more sort of interaction with colleagues. What's important in this area is is, come back to sort of one of our favourites again, is the policy that you've got in place, isn't it, James?
Yes, in short, it's very important to have a good flexible working policy. Having an updated and clear policy, it's helpful to both employees and employers by providing a structured process for handling requests. The statutory scheme sets out specific timescales and requirements. These timescales being that employers have 2 months from the date of a flexible working request to make a decision, and that includes any appeals. So having a policy which sets out a clear procedure, which should include sufficient consultation with the employee, as well as the timescales and relevant considerations, that can all help streamline the process and ensure legal compliance. Some employers also include standard documents such as request forms, consultation meeting invite letters, acceptance letters, rejection letters, which can be tailored to the specific circumstances. And these all help ensure consistency and as well efficiency.
Thanks, James. Yes, consistency is, again, much like with any sporting refereeing decisions, that's what we want, isn't it? Consistency, and consistency in terms of those documents that are used and reasons that are given, absolutely crucial here. What other tips do you have, James, for employers when they're dealing with flexible working requests?
So I think firstly, it's important that employers try and take a positive and collaborative approach to flexible working requests. Requests should be dealt with transparently, and employers should engage in meaningful dialogue with the employee to try to better understand the request. Dealing with the request in this manner can not only reduce the legal risk, but it also helps to promote a more supportive working environment. So rather than focusing on, let's say, the minor issues with a flexible working request, employees could prepare impact assessments looking at the adverse consequences of the suggested working pattern and discuss them with the employee. If a request can't be granted in full, employers should try and overcome obstacles and consider alternatives. Alternatives being trial periods to assess the feasibility of a flexible working arrangement. If the trial period works, then brilliant, the arrangement can be made permanent. If it doesn't work, then this still puts the employer in a better position to refuse the request and defend any claims which may follow.
Thanks, James. And what if you just can't accommodate a request? What do you do?
So that is a reality for employers. If there's no alternative, and an employer can't accommodate a request, they should ensure they have evidence to justify the refusal. The Employment Rights Bill will make various changes to flexible working, one of which will be introducing a reasonableness test. As such, employers who are able to evidence and justify why it was reasonable to reject a request, they will be in a much stronger position to defend claims. So, for example, if an employer is refusing the request based on the burden of additional costs, they need to be prepared to justify what these costs would be and why it would not be reasonable for them to take these costs on to accommodate the flexible working request.
Thanks, James. And if an employer rejects a flexible working request in accordance with the statutory scheme, then that isn't necessarily the end of the matter, is it?
So that's correct. So even if an employer deals with a request in line with the statutory procedure, employees with certain protected characteristics may have discrimination claims, for example, indirect discrimination and failure to make reasonable adjustments. That's if their flexible working request isn't handled appropriately. So it's common for carers to request to work from home due to a need to look after a disabled relative, or a woman returning from maternity leave requesting a change in hours because of childcare commitments. So employers need to be particularly mindful of the reasons behind a flexible working request to understand any potential discrimination risk. And that's why it is important to have open dialogue and consultation.
Absolutely. And just on that point, I mean, we're going to, I don't want to sort of spoiler alert, but we're going to come on to discrimination compensation later, Lindsay, aren't we? But I think we do see in cases that James has just mentioned, if you are caring for a disabled relative and that's why you are wanting to work more flexibly, then that is a highly stressful time that you're going through, and if that request is not dealt with in a reasonable, compassionate and appropriate manner, then you are going to find yourself in the upper echelons of the potential awards that a tribunal will make against you, and you're going to find that your arguments are given fairly short shrift by the judge. So I think again, just sort of trying to sort of bring it to life a bit. Yes, you've gone through the statutory scheme and you've ticked that box, but if you haven't really applied your mind to the bigger issue sitting behind the request, then the story is going to continue, and it's not going to have a very happy ending when the checkbook has to come out. So anyway, but we need to keep it light. You're
doing a dreadful job of that, Robert, I'm afraid to tell you. A lot of doom and gloom here.
Well, look, as a Nottingham Forest fan, it's all light, but I don't want to get complaints on a football basis, so we'll move on from the stunning success of Nottingham Forest's season this year. In terms of flexible working requests, the most common request that we see is for people to work remotely. James, do you anticipate employees being more willing to return to the office if the economy were to slow down in the second half of this year? I mean, obviously, hope, fingers crossed it doesn't. But what do you see on that front?
Well, typically, we've seen that when the economy shows signs of weakening, employees actually often get concerned about the state of the job market and what this means for their job security, which can result in fewer flexible working requests.
Yeah, and I think people being perhaps more prepared to work in the office more, but we'll see on that front, and hopefully 6 months we can be talking about lots of job creation and good news. If an employee does choose to make a flexible working request, what are the risks? I think we probably covered some of them, of employers handling that request poorly or inappropriately.
So there are significant risks associated with not handling requests in the right way. For example, if you fail to deal with the request within the statutory time frame, fail to consult before refusing the request, or fail to handle the request in a reasonable manner, then an employee would be entitled to bring an employment tribunal claim, which could result in a compensatory award of up to 8 weeks' pay, as well as an order to reconsider the request. The risks become more significant where the requests relate to childcare, health conditions, or any concerns related to a protected characteristic. So handling requests which relate to any of these areas can expose an employer to the risks of an additional claim being brought for discrimination, and an injury to feelings award is technically uncapped and can often attract significant coverage in the news.
Fantastic. Thank you, James. Lindsay, if an employee does end up bringing a discrimination claim in the tribunal and they are successful, perhaps for one of the reasons that James has just outlined, then what type of compensation could they be looking at if they win their claim?
Well, to be honest, Robert, it really depends on how serious the discrimination is. But I guess the key thing to remember is exactly what James has just said there, that there's actually no upper limit on compensation for discrimination, unlike in claims for unfair dismissal, etc. The calculation for compensation for discrimination is based on the loss a claimant has suffered. And that's usually made up of things like their financial losses and then the injury to feelings award that James mentioned. But it can also be other things like personal injury or aggravated damages.
Okay, thank you. And when you say financial loss, what do you mean?
Oh, well, it tends to cover things such as loss of salary, loss of pension, out-of-pocket expenses for things like medical treatment, counselling, for example. The whole purpose of compensation is to put the claimant in the position they would have been in but for the discrimination. So that covers past losses, so losses from the date the alleged discrimination took place right the way through to the remedy hearing. So that's salary and other benefits. But if the claimant has perhaps received any sort of earnings during that period, so for example, if they've had any sort of benefits, so job seekers allowance, universal credit, etc., or they've actually managed to get another job during that period, that income will be deducted from that payment. But compensation also covers things like future loss, which is, I'll be honest, you and I both know, it's quite speculative in terms of calculations, and it's really an estimate of what the claimant's future salary and benefits is likely to be. And the tribunal has to decide at what point it considers the claimant's future loss will stop. So if at the date of the hearing, the claimant has, as I mentioned, kind of obtained a new job, which just pays substantially less, or has not been able to find a job at all, then the level of compensation awarded could in actual fact be pretty substantial. In rare cases, compensation can also be awarded where the employee is able to argue that the discrimination has effectively ended or caused irreparable damage to their career. So lots of costs here, lots of money.
So plenty of food for thought, and you're absolutely right. If you're in, for an example, late 50s or early 60s, and you're dismissed in a discriminatory manner from a well-paid job, then you're going to find it tough to find a role at a similar level. So in those kind of situations, the normal cap of a year's salary for unfair dismissal claims is removed, and you are potentially looking at some very, 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 very big numbers.
And sorry, Robert, I was just going to say, no, the other time that you also get that is not just the age thing, but it's also where you're in such a kind of small community of kind of labour or a kind of very skilled or very niche role where there are very few job opportunities available to you in the workforce. And if your reputation, for example, has been slandered, then again, similarly, you can find that you're getting these kind of bigger numbers, and the kind of standard 1 year kind of cap on future losses that we normally talk about or base our calculations on is kind of thrown out the window.
Yeah, absolutely. And when you refer to injury to feelings, what do you mean by that, Lindsay?
Oh, well, that's the award. So that essentially means it's the sum of money that's paid to the claimant to compensate them for the upset that the discrimination has caused them.
Okay, thank you. And how does a tribunal decide what level of injury to feelings award to make?
Well, actually, so there was a case, actually, no, I was going to say recent, not that recent, a case that we just generally refer to as vento, and that's where you get this kind of vento bans from. So that's where the court set out really clear guidelines for the amount of compensation that's to be paid, and it's split up into 3 bands: the lower, the middle, and the upper band or the top band. So lower band is essentially for less serious cases, such as where the act of discrimination is isolated or a one-off occurrence. Middle band, that's for serious cases where it doesn't merit an award in the highest band. And then the top band is for the most serious cases, such as where there's been a lengthy campaign of discriminatory harassment on the grounds of sex or race. And only in the most exceptional cases would you normally find that the tribunals make an award at the top band. Or indeed it's even rarer, Robert, for them to be making it an award that exceeds the top end of that band.
Thanks, Lindsay. You referred to these bands. Do we have any idea as to what actual figures we could be looking at, depending on which band we fall into for an award?
Yeah, of course. Nomi, I think we actually might have it set up in the next slide, if you can click through for me, please. But yeah, brilliant, thank you. So yeah, as you can see on the screen there, we're lower band, it's 1,200 to 12,100, middle's 12,100 to 36,400, and then top band is 36,400 to 60,700.
Thank you. And can you give us an example to try and explain sort of what kind of discrimination or the acts of discrimination would result in an award in one of those bands, please?
Yeah, of course. So Forstater is probably the one that we always kind of talk to about this. So that's Forstater against CGD Europe Limited. So in that case, it found that Miss Forstater had suffered direct discrimination because of her expression of her gender critical beliefs, including the belief that sex is immutable and should not be conflated with gender identity, and that trans women are men. Now, the tribunal found in that case that the discrimination fell at the top of Vento middle band. So we're looking at that middle band on the screens, but the top end of that, so you're kind of towards the 36,400. And in actual fact, they awarded her £25,000 for injury to feelings, and that was based on the bands that were in place at that time. And I guess that's a good point for me to note there, Robert, that in actual fact the bands get updated on a yearly basis to kind of go in line with inflation, etc.
Okay, thank you. It's interesting because if you read the press here and certainly here in America, there are some very, very, very big numbers that are thrown about in terms of awards at a tribunal for discrimination, and there's a much bigger numbers than the numbers we're looking at here.
Oh, definitely.
Why, in that case, why did the tribunal decide that those discriminatory acts put it into the top of the middle band as opposed to, say, putting it into the top band?
Oh, yeah. Well, to be fair, in that case, the discriminatory acts were considered to be significant, Robert. So evidence showed that the respondents didn't actually want to be associated with Miss Forstater, and that affected her status within the wider professional world. So that kind of comment I made earlier about kind of really limiting your opportunity to move elsewhere if you're in kind of like a niche sector or a niche role. And although the act occurred over a kind of period of a number of months, tribunal acknowledged that their consequences had lasted much longer. So she was actually awarded over £100,000 in damages. So yes, you're right, not the big numbers that you see in American cases, and certainly not the numbers you see when you get a schedule of loss in from a claimant that's talking millions. But she was awarded £100,000 in damages overall, which included that loss of earnings award of the £25,000, and then aggravated damages of £2,000 due to the respondent's behaviour.
Okay, thank you. We'll come on to aggravated damages in a minute or so, but I think, as you say, the point we're trying to sort of stress here is that when you receive a schedule of loss or a letter or email out of the blue saying things have been terrible for me, pay me $250,000, we need to always link that back to the figures we've got here, because people aren't shy in terms of the numbers that they frequently put forward and have got no relation to how actually an award would be determined by a tribunal judge if you actually got home and were successful in your claim. So that case, obviously a fairly serious pattern of discrimination over a prolonged period of time resulted in an award in the middle band of Vento. What kind of discrimination would fall within the lower band, Lindsay?
Oh, lower band. So that tends to be just one-off cases, so isolated comments, so a kind of one-off racist comment, or a comment that amounts to kind of sex or race discrimination or harassment. That's probably when you're looking at the kind of a lower band.
Okay, thank you. And I'm slightly conscious that my poor football chat has probably resulted in us a little bit short of time. So thank you for bearing with us. We'll probably sort of just do 2 more points, and then one, if you've had technical difficulties on this, then I'm very, very sorry. This is recorded and it will be sent round to everyone. And secondly, the questions that you've raised, we're not going to have time to cover those today, but we will cover them off and we'll pick those up with you separately. So, but thank you for dialing in. So 2 more questions, and then I promise you we will go. Everyone's going to want to know, Lindsay, top band. What puts us into the top band for discrimination awards?
It's the key question, is that everybody wants something in the top band. So basically that's usually reserved for lengthy campaigns of harassment and discrimination. And the one case that is probably really good to flag here is the one of Aitchison against Avon Fire and Rescue Service. So Miss Aitchison worked as a firefighter, and she alleged that she suffered as a result of a misogynistic culture within the fire service. So her claims were for constructive dismissal, direct discrimination, harassment and victimisation, all of which were successful. Now, the tribunal found that there were acts there which included belittling her, ignoring her, praising male firefighters for doing certain acts, but not praising her for doing the same acts. Male colleagues openly and frequently making sexist comments, sexist banter that can't get through a webinar without using the B word. And then, I mean, there was even somebody suggesting that, you know, asking questions whether a new recruit was fit, or somebody suggesting that she'd watched porn with somebody else. I mean, it's wild when you read it. I mean, we're even talking about things like suggesting a women's place is in the kitchen rather than in the gym, which all of my fitness lovers will be absolutely horrified about. And in actual fact, I think when the tribunal looked at it, it was kind of covering the points that we mentioned earlier, Robert. The tribunal looked at it holistically and essentially decided that she'd intended to spend the rest of her career in the fire service. But as a result of this, she'd had such a kind of unsurprisingly bad reaction to it, and as actual fact being diagnosed with PTSD, they recognised that this had such a significant the impact on her life long term, that she was actually awarded the top end of the top band, and she was given a 35,000 for injury to feelings in that respect, or for that.
Thanks, Lindsay, really helpful. Just quickly, everyone, in terms of, you can also have an aggravated damages award made against you if you act in a malicious or insulting manner. So, you know, best example of that is you end up promoting someone or giving them a pay rise because they have behaved in a discriminatory manner, which, believe it or not, does happen. And a final question before we go. This is all employment focused, and you know, we've run out of time, but there is one other point I just wanted to cover off, which is obviously there have been a number of significant announcements from the Prime Minister and others on the immigration law front. And as our head of immigration, Lindsay, could you take your employment hat off, please, and put your immigration hat on, and just give us a quick update on those announcements and what we need to be looking out for, please.
Yeah, of course, Robert. It's been a wild couple of days. Key things for kind of all of our HR contacts and friends that have joined us today is probably the significant changes proposed to the skilled worker route. Essentially, we're looking at the skill threshold being raised back up so that you need to have a degree qualification in order to be able to access the skilled worker route. We're also likely to see yet a further hike in the salaries expected for that role. And then also, problematically, they are looking to move settlement from 5 years to 10 years, which means that we're likely to see that employers will have to sponsor workers for a full 10-year period before that they can move to settlement, which means double the cost, double the work. So sorry to end on a horribly doom and gloom note, but not brilliant news for businesses on the immigration front either.
Thanks, Lindsay. Interesting stuff. So we will end on a positive note. So thank you for dialing in, everyone. Really appreciate it. And thank you, Lindsay. Thank you, James. If I can just draw your attention very quickly to, we've covered a lot. There's a lot that's going to come down the track in the next couple of years. So we have created a hub on our website that details all of the employment law changes. So not just the Employment Rights Bill, but it's all of the employment law changes over the next couple of years. You'll be able to access that via the link that is shown there, but that will be circulated to everyone afterwards. Or again, if you do visit our website, then you can just access it on the employment part of that. But thank you, really appreciate it. Sorry we've run over. We will come back to everyone on questions that you've raised, and if you have other questions that you haven't raised in this, then please just let us know. But have a lovely rest of your day. Kate Gardner, another employment partner in our team, will be doing our next webinar on the 16th of September. So please do put that in your diaries for some post-summer holiday fun, and hopefully look forward to speaking to you all soon. Thank you. Cheers. Bye-bye.
Thanks, everyone. Bye.
Thanks, everyone.